Welcome to the Law Awareness Weeks. This webinar is part of the Law Awareness Weeks at CDC 2025. It's a collaboration between Bono, SG, the 5 Community Development Councils, National University of Singapore Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, the Singapore Corporate Council Association Pro Bono Chapter, and the Singapore Association of Social Workers, supported by the People's Association. I'm Tarun Samtani. I'm your moderator for this webinar. Just as a quick introduction, I've been in the industry, cyber industry, for about over 2.5 decades, being part of the cyber data privacy, data protection, and AI journey in the last, many years. Looking forward to this conversation itself. With that, I would like to introduce our panelists for today's webinar, Mr. Jeffrey Lim and Ms. Veronica Tan. Jeffrey is a co-managing director of Joyce A. Tan & Partners, LLC, and he specializes in intellectual property, data protection, cybersecurity, data governance, and artificial intelligence. He's a SAL Senior Accredited Specialist in Data and Digital Economy, an honorary legal advisor to and a fellow of the Singapore Computer Society, SCS, and a member of the Singapore Chinese Chamber of Commerce International's Technology Committee. Veronica oversees the Safer Cyberspace portfolio in the Cybersecurity Agency of Singapore and is responsible for the national cyber resilience of organizations in Singapore. Her team worked on the Cyber Essentials and the Cyber Trust certifications, which are national cybersecurity standards to guide organizations in managing their digital risks effectively. Jeffrey and Veronica, thank you again for joining us today. Today we'll have 2 sharings from each of our panelists, and this will be followed by a panel discussion on various scenarios. We'll probably kickstart first with our session with a presentation by Veronica. I'll hand over to Veronica.
Okay, hi everyone. So I think in today's sharing, I'll be talking a little bit about some of the digital habits as we use a lot of digital in our daily lives, both at work as well as at play. Right, so let's start with the first scenario, which is deepfake. Now, we have seen that artificial intelligence has been rising, and this has also resulted in deepfake situations. This happens both in our workplace as well as in our daily lives. So let me start off with the scenario on the left in a workplace. Perhaps you could be an employee and you have a senior management team who has gone overseas, contacted you rather in a very urgent manner to tell you that he would need you to actually do a funds transfer to a new partner that he has just met in a meeting overseas. And this could be a deepfake scenario in this case, because this is something which actually really happened to one of the companies in Hong Kong, and one of the employees was actually duped into doing a funds transfer away. In the personal scenarios, it could be something similar where you, as a family member, would receive a call from another family member telling you about an urgent scenario and asking you to do a funds transfer, for example. And if you look at these 2 scenarios, if I just click on to the next slide to show some statistics, we have seen the rise of artificial intelligence and the ability to create more and more realistic content. So I think as far as a few years ago, it potentially could have been possible to be able to detect signs of deepfake, but the technology has progressed to the state where it could be quite difficult now. And these are some statistics that we have from a recent cybersecurity awareness survey. So I think when surveyed, about 80% of the respondents were confident in identifying deepfakes. However, when they were actually given a real content versus a fake content, we found that only 1 in 4 were able to distinguish the differences between a real and fake content. Moving on to the next slide. So then the question logically for all of us is, in this scenario where it's going to be quite difficult for us to be able to tell real from fake content, what would be some of the mitigation measures that we can think about and make sure that we are hopefully not at such high risk? So I think one of the good measures would be, as far as possible, try to limit public information being disseminated about yourselves, for example, plans to go overseas. And this may be a little bit hard in this day and age, but it's also to try to limit public and audio and video recordings of yourself. This is because technology has improved so much to the extent where threat actors no longer need to have a very long audio or video clip of you in order to create the deepfake, and it's possible to do it with a much shorter clips. The other example that I may want to give is actually in the form of safe words or safe phrases. So imagine if you were called to be getting on a call with either a family member or somebody that purports to be your colleague. How do you verify that this person is really who he or she claims to be? So be it in the personal scenario where you can establish safe phrases or words with your family members, or in the workplace, you could be asking a question like, hey, what was the book I loaned you last week? And a question where only the intended recipient would have the answer. This could be one way for you to be able to figure out if the target audience that you're speaking to, is it real or fake? And of course, the other way is to take on offline checks. For example, hang up and basically call the person back at a known reachable number. So let's move on to the next scenario, which is also somewhat AI related, called bring your own AI. So let's start with the first scenario in the workplace, where it is a situation that may happen to you in the workplace where you are busy and you've been asked to generate a meeting update from some customer information, and you may think that it's actually quite easy and quite fast to stick it into one of the generative AI tools to help you to generate this information. If we show some statistics that have been published, we have seen that in this case, about 40% of companies may have purchased a large language model, but we have also seen that there are 90% of employees using large language models regularly. So if you compare the two numbers, what does this tell you? That perhaps some of these employees that are using the large language models may be using something that has not been sanctioned or authorized by the company. And this could be one of the existing third-party tools that is accessible to employees, but maybe not necessarily cleared for putting in official or corporate information. If we look at the next scenario, which is in our daily lives, what is at risk is probably not corporate information, but actually information about yourself. For example, it's common to have many of these consumer tools where we can upload our photographs, as seen in this picture here, and get the generative AI to help to edit the post or something else. So I think in this case, what is at risk is your own personal data. Could there be situations of data leakage? Could there be embedded metadata such as location in your image that could also be given away? And the other question that you may need to ask is really to think about what are some of the data used by AI providers, and would you be subject to potentially use of your data for training or for image manipulation? So I think in mitigating some of these, if we move on to the next slide, these would be some of the things that we can think about. In our corporate use, let us check against our corporate terms of use of data. For example, have our organizations purchase corporate tools that we can use? Or is it the case where only specific classes or categories of data can only be used in a third-party generative AI tool, for example? In the personal lives, I think let us also be vigilant in checking the terms of use of the AI provider, how they can use your data, and whether it can be used for training, for example. The other one that we may need to be careful about is really to have a sense of what the track record of the AI provider is in terms of their cybersecurity posture and their responsiveness in upgrading, for example, if there are known exploits or vulnerabilities discovered. Now let's move on to the next scenario. This is a scene that took place in the US several years ago, where people were rushing to top up gasoline, and there were cases where, the gas actually ran out. So what happened is the case of a Colonial Pipeline, which is an oil pipeline in the US, serving many major states, and they had to shut down the pipeline in a hurry. This was the result of a ransomware attack on their IT networks. They were worried that it would percolate to their OT or operational technology networks or the gas pipeline network, which is why they had to shut it down. And if we were to trace backwards what actually happened, what literally happened was actually a password credential issue. One of the employees had a password that was breached and compromised, happened to have reused the same password in the corporate setting, and this was basically then misused. And what made it worse was the fact that there was no multi-factor authentication put into place. So if we move on to the next slide, I think this impact would show us the importance of protecting our credentials and having a second factor to authenticate. If I take your attention to the bottom right-hand corner that talks about passkeys, I think this is where major tech providers such as the likes of Apple, Google, as well as Microsoft are trying to move towards introducing the concept of passkeys simply because I think for all of us as humans, having to remember passwords and having a lot of credentials to deal with makes it really difficult, and it really creates a lot of opportunities for vulnerabilities. However, having said what I said, while the big tech players are moving towards passkeys, it is still a fact of the matter that today we still have to manage passwords and basically keep them safe. So in the meantime, here are a couple of tips in order for us to stay safe and protected. In terms of passwords, usually it is a matter of length over complexity. But we are humans. Asking us to remember long passwords makes it difficult, especially if it's complex. So the industry has also converged on a couple of quick tips. For example, the creation of passphrases, random words strung together to make a phrase. And basically, when you make it sufficiently long, it would be somewhat helpful in making it a strong passphrase. However, this is also not enough, and that's why we also need our second factor authentication. So if the password or the passphrase is something that you know, the additional factor that we can implement would be something that you have, such as the Authenticator app or a smart card, or in some cases, something that you are, such as your fingerprint and your face scan. So think about it, something like your main door as well as your gate. So just in case the lock on your main door has been impacted or has been breached, you still have your second factor, which is your gate, to serve as a protection so that intruders cannot get into your home. So basically, this is a very similar concept from the perspective of password control and credentials access management. Now let us move on to the next scenario. Software update available. How many of us are guilty of this scenario where we see this window popping up but oh no, I'm busy, I have a report due, I do not want to interrupt my work. So what do? If I click next, we cancel this transaction. And I think what really happens is, in some cases, the software updates actually carry important security updates to close and patch certain vulnerabilities that are existing in the software. So I think if we know that this is something important, let us also try to make it a habit to actually allow that software update to take place so that it closes the security holes in our software. Studies have shown that sometimes there have been software vulnerabilities that have been published and existed for many, many years, and yet attackers are still able to use these exploits in order to get into the corporate device, into the corporate network, and so on. So it's really something that we need to think about and how we actually practice our daily cyber hygiene. Now moving on to the next scenario, which is staying safe on the mobile. So there's this phenomenon called BYOD, or bring your own device, where you may take your personal device and you may use it for your work-related purpose, whether it is to access or to store work-related data or to access your work environment. So it really depends from company to company. Some companies are prohibited, some allow for it but have specific terms of use. So I think in taking our mobile devices to work, let us also check and make sure that we follow our company guidelines so that we're able to be safe and secure as we go about doing our BYOD. On the right is then you in your daily life and how you make use of your mobile. So just be careful of things like phishing that can actually try to steal your credentials, or opportunities where it looks too good to be true, asking you to download a side-loaded app in order to proceed with the transactions. And these are some of the common vulnerabilities where people do fall prey in the case of a mobile phone usage. So I think I've come to the last slide of my sharing. Just a couple of links on some of the CSA cybersecurity toolkits, which is useful for employees, for business leaders, as well as for IT and cyber personnel, just in case you find some of these tips useful. Most of the tips that we have would be covering organizational usage, but actually they are also equally applicable to you in your daily lives as we go digital in the way we live and play. And I've come to the end of my sharing. Thank you very much.
Thank you so much, Veronica. I'm pretty sure that was pretty useful for a lot of the people out there. We would like to invite Mr. Jeffrey here to share some legal aspects of cyber hygiene. So Jeffrey, please take it away.
Hi, everyone. So this is an opportunity, I think, for all of us as laypersons and practitioners to just refresh the fact that the law has actually been changing quite rapidly to give people opportunities to deal with cyber situations. So cybersecurity, cyber safety, it's quite holistic. There are all kinds of issues that can come up in terms of engagement online. And so if we think about how the law has been evolving, I think on the first slide, you'll see that there's quite a lot of different rights that have emerged. So this is a list of some of the key ones. There are about 6 ones I'll be talking about today. You'll see that a couple of these should be quite familiar to you. This is the first one is the PDPA, the Personal Data Protection Act. And this really addresses things like abuse of personal data. If an organization is abusing the personal data that you've given it in the course of your interaction with them, then you have certain rights that you can turn to address your concerns. And so with the PDPA, it's important to first recognize that there are actually a bundle of obligations that are imposed on companies that collect your personal data. And it's really a piece of legislation that gives you a framework for handling the collection, use, and disclosure of personal data by organizations. Now, when we say organizations, we're really talking about private organizations. The PDPA doesn't apply to government agencies and public bodies. They have their own legislation or regulations and standards to deal with. But the important thing to recognize also is that this is really targeted at organizations, right? So the PDPA doesn't actually grant personal individual rights to someone to go after another person for his personal domestic use of your personal data. That would be a separate type of issue. But the PDPA was really intended to sort of uplift standards through industry. And by doing so, essentially, we'll see that as the years have gone by, and the next slide will show this, that actually there's been a steady stream of individuals and members of the public who have come forward to the Personal Data Protection Commission, the PDPC, to seek redress and to file complaints. And the numbers do show that it's quite well used as a forum for addressing concerns. And the PDPC has done a very good job holding organizations to account. Now, there is a right of private action. That is to say, you can sue the organization directly, but it's a practical question of access to justice, right? How costly it would be to engage a lawyer to bring a legal action on your behalf, versus perhaps going to a regulator and having a regulator take the appropriate steps to hold an organization accountable. So given that is the situation in mind, often we see complaints filed with the PDPC directly. So if you do think that an organization has placed your personal data at risk and has done things with your personal data that was not within scope or contemplation or your consent, you should feel free to move forward and place your complaint with the PDPC. There's also another right that has emerged, and this is under the POHA. This is the Protection from Harassment Act. And what you'll see under POHA really is a wide range of things that are meant to, that the public is meant to be able to take redress from. It's not exclusively about online conduct. It can also be conduct offline. But the key thing to recognize is that when it comes to certain online conduct that you see, cyberbullying, threatening or abusive behavior that you see online, these are all types of activity which POHA could be used to address concerns. So this is another way in which the government have stepped forward and given rights to online citizens in their online world. So recognizing that these 4 main things, which is Section 3, intentionally causing harassment, Section 4, threatening, abusive, insulting words, 5, instilling fear, provocation, 7, unlawful stalking. These are all real situations that can come up in the online world, and recognize that there is some redress for you should that happen. And in fact, I think the next slide would tell us that effectively there are also resources for you. Now, this is taken from the government website that gives you resources where you can take action should you need guidance in terms of moving forward with POHA. The resources there online are all essentially guides to help you take a complaint forward. Now, I do recognize that it is legal proceedings. There are elements of where you have to put forward evidence. So when you are acting in relation to a POHA matter, it would be important to substantiate the issues that you're engaging. So evidence taking, tracking, and making sure that you've got what you can record in terms of proving your case is important. Now, we're talking about POHA, but there's also the threat posed by malicious actors. And we've had a long standing law, I think since the 90s, of the Computer Misuse Act. And this act addresses essentially what we often refer to as hacking. But I think it's evolved over the years. When it first came out in 93, there was a range of offenses. And then there were these were the sort of classic offenses. But you can see that essentially as online conduct and online hacking has grown in terms of variety and different ways of attack, so has the number of crimes that's been added to the CMA. So the FIR you see here, section 3, 4, 5, 7, are the generic crimes. These are the ones that have always been with us. And these are quite widely worded. They're technology neutral. In other words, they're meant to apply through any range of technology, and they're also intended to be evergreen in that sense. And you should be able to, if you find that there has been hacking on your device, you should be able to fit most of them in these areas. But the next slide shows us that effectively cybercrime doesn't stay still. And so new offenses were added. And these that you see here really include all the new types of activities which has been criminalized in order to ensure that individuals can take action and the public authorities can take action when prosecuting offenses by individuals who are perpetrating these issues. Key to these new offenses are activities which are often, you can often see even dealt with on the dark web, where individuals might be selling passcodes, they might be helping or supplying malware to criminal actors. In fact, the dark web is full of actors that can provide a virtual supply chain for various criminals who wish to perpetrate attacks. And it's important to recognize that the CMA has also been basically enhanced to address these potential risks. Now, perhaps to move on from the Computer Misuse Act, there's another piece of legislation fairly recent, which is the Online Criminal Harms Act. And this is meant to target scams and malicious activity, where a list of specified offenses, these are the offenses that also existed in the offline world for years. There's been recognition as to the bringing in of these specified offenses under the framework of a piece of legislation that targets the online world where this happens. So scams and various issues can happen. And particularly if there are communications as well, which are harmful. The Online Criminal Harms Act is one of the ways in which you can seek redress. And this can be in the form of stop communication orders, orders to stop the dissemination of the blocking of harmful information. It can be targeted at deep fakes. So, with the application of certain remedies under the Act can be used to stop the propagation of false messages or individuals who find themselves being mimicked by deepfakes, leading to real serious harms. And there is an online safety commission that is intended to help address communications and engagement with the public on these needs. You might have also heard of another piece of legislation. We call it POFMA, P-O-F-M-A. It's just short for essentially dealing with the potential for online falsehoods. Now, this was intended really at protecting national security in some ways, the harmony and certain matters of social balance and operation of society. Certain falsehoods can be spread and weaponized by those who are attempting to essentially inflict harm on us as a society. So POFMA was really passed as an act to help address targeted takedowns or action against activities that can, statements and in content that can be that harmful. And you'll see on these headlines that you have that it isn't just targeted at the people who create the falsehoods. It can also be used to target channels for communication where the falsehoods could spread. Now, more recently, there is the Protection from Scams Act, and this is very targeted legislation that is intended to help individuals who find that they may have been the target of a scam where would have been duped into providing instructions to their banks to transfer monies, perhaps to an account held by an attacker or malicious actor. And if you remember, if you can see the pattern that was involved before the act was passed, often what would happen is the attacker would dupe someone, have the money transferred to an account, and then very rapidly that account would then be emptied as the money gets routed out. And therefore, it becomes harder for someone to actually try and recover the money. So once it leaves your account, you have a real problem of trying to get it. So the Protection for Scams Act was really intended to help freeze potential victims' bank accounts. And the idea was that if you realize that, hey, I might have been duped, I might have given instructions to my bank to facilitate or to transfer money to a scammer, this act actually gives you an opportunity to approach a police officer and essentially try and get some order to stop the bank from executing it. Now, the remedy essentially is a restriction order, and we'll see that here. The specified officer, the police, is essentially the person who you're engaging with. The orders themselves, if you think about it, an order to stop banking transactions is itself controversial because a lot of legitimate commercial transactions depend on timely payment. So when the act was passed, it was intended to have a number of protections to ensure that we balance the interests of legitimate businesses versus the actions of malicious threat actors. And so there is a time period linked to how long you can stop money orders. It can be extended, it can also be lifted. And so there are various procedures in place. But if you do find yourself targeted by a scammer and your monies are actually at risk of being moved out, this is a useful development legally that you can avail yourself of. Now, I think we have all these laws, but I think it's important to recognize that with or without these laws, you still need to do your part. And this is, I think, nowhere better evidence in the way how individuals, I think, treat legal terms and conditions on apps and devices. So, now the reality of it is all legal terms and conditions addressed to your lawyer or to you? They're actually addressed to you. And if you feel that your data privacy, your data, your security is very important, then why do most of us just click agree and move on and not read it? It can be difficult to read, and I do see T's and C's that go on for pages. So yes, I understand the challenge, but it is important to distill and understand what exactly you're agreeing to whenever you engage an online platform or app. And it's important to recognize that this can have implications. Now, for all these issues, we do see also regulators are trying their best to regulate content, competition, and activities. But the truth is that it's going to start with you, and you need to pay attention to actually what's being done at the organizational level. So I also want to talk a bit about organizations themselves. So there's to the extent that you are part of an organization and you're taking steps and you're participating in the use of personal data or engaging users, it's important to recognize that there are things that you should be doing to protect yourself. Veronica's already covered a number of them. She's done a great job of splitting things up between professional and private. So it's important to recognize that, yes, these are not safety measures that you should ignore in either sphere. And I probably won't go through them at this point. I want to talk a bit about the legal recourses or avenues for individuals at the end. So we can go past to the last slide. And here really just the reporting channels of where you can go should you find yourself caught up in a situation. There is, for example, a breach reporting link here for the PPC should you discover that there's been a data breach. You can also report scams and calls to the Singapore Police Force. That's the hotline, and there are various information online linked there as well. And then there are also phishing, extortion, scam emails that you can send information on to the cybersecurity agency. And that also is a link. So one of the things that we would ask that every individual take an effort to look at is to be aware of what your bank, your healthcare provider, your government agencies, anyone who's holding personal data that's important to you, what they're telling you, the advisories, do pay attention to them. It's often the case that these organizations are doing their best to try and manage your risk as well, but you also need to do your part and sort of reciprocate and join them in all the efforts that they're taking to protect your data.
Thank you, Jeffrey. That was very, very extensive and helpful. Actually, I'm pretty sure many of the people in the audience would have been interested in that resources that you gave. Really, I suppose that's a pretty good one. Now, thank you both of you for that great sharing. Let's probably look at some of the scenarios that we would be discussing going forward from here on, because until now it was more about sharing actually, but I would like to kind of take the conversation to the next level, which is more about having a discussion together and just picking up some scenarios that we've kind of got, analyzed around it. Maybe for the first scenario, Veronica, I think you probably already kind of gave an example about one of the data breaches around, well, the data breaches I call it around the impersonification kind of a breach there. And in Hong Kong especially. I'll probably use this as a different example now here, but slightly interesting, I suppose. David, a finance manager at a multinational company in Singapore, receives a WhatsApp message from what appears to be his CEO's number, complete with the CEO's profile photo. The message urgently requests David to join a Zoom call about a confidential acquisition. During the video call, David sees and hears his CEO, CFO, and the other senior executives discussing the need to transfer $400,000 immediately to secure the deal. The executive voices and facial expressions seem authentic, and they reference recent company meetings David attended. Trusting what he sees and hears, David authorizes the transfer. Only later does he discover that the entire video call was generated using deepfake AI technology. That is happening quite more often than you would imagine. Maybe if I may ask, maybe Veronica, to kind of a couple of questions here. Veronica, what warning signs should David have noticed, and how can organizations protect against deepfake scams in that case?
So I think if you were to look at some of the typical guidance in terms of trying to identify and a deep fake or AI generated pictures, the typical guidance would be to look for things like incorrect shadows or for lighting, or things like missing or misplaced objects or body parts. But earlier on, I was also saying that actually increasingly the technology is improving, and there are quite a couple of studies out there that show that it's increasingly difficult for us as humans to be able to tell what's real and what's not real. So I think from an organizational perspective, you probably have to think of it from the perspective of not just a single measure, but a few measures coming together. And let me talk about the people, the process, and the technology. So let me talk about the technology first. There are some technologies being developed, such as fingerprinting and watermarking, that try to mitigate this issue. For example, think of this as something like a content credential. And basically, if there's a watermarking or a content credential, it would give the sense that this is actually genuine content. But this in itself is also not exactly foolproof, simply because if you look at all the contents out there on the internet, most of them actually do not have such a credential yet at this point in time. The other issue is, of course, the fact that technology is always improving, and there's also been results and studies to show that some of these can be tampered with or they can be foiled. So this in itself is not foolproof. The other piece of technology that people are looking at would be something like liveness detection techniques. So not too long ago, I think the MAS, the Monetary Authority of Singapore, issued some guidelines and advisories on deepfake situations in the case of the financial sector. One of them talked about deepfake images, if I'm not wrong, being used for the digital KYC process. So I think they also mentioned potential liveness detection techniques to augment the existing technologies. For example, in this case of a facial biometric authentication systems, you could be trying to detect manipulated videos through motion analysis, texture analysis, or behavioral analysis, for example. Or it could be something like prompting the user to perform specific actions to respond to stimuli during the verification process. So that very much covers the technology piece where, things are still kind of developing and not quite exactly foolproof and comprehensive. So that's where the process comes in. And some of the process measures would be things like implementing offline or second layer of verification or checks. So in a case of this scenario where it's a high risk or high monetary value transaction, and it's probably not just to follow instructions immediately, but to have a second line of verification and checks in order to, basically do some checks before you proceed and execute the transaction. But I think right now, most importantly, is really about the people. So given that things are relatively nascent, probably the most powerful thing is also to make sure that we have sufficient level of people awareness training and awareness so that employees are all aware of such a scenario. What are some of the warning signs, for example, for deepfake and social engineering, and make sure that they are alert so that they can be prepared to jump on board and to ask next level questions when things do seem a little suspicious. So people, process, technology put together should be a much more holistic response to this situation.
Great, Veronica. I think that's really good advice over there, actually. In fact, on the point that you mentioned about the technologies where they're going to be having some content watermarking, I think what I've also seen is, in fact, there are technologies available that can remove the watermarking actually these days. So that's pretty tough the way things are going with the AI stuff. But maybe I think if I may invite Jeffrey kind of on one of the questions on this topic, can the company actually do anything in such a situation, or is it too late?
Well, it's not too late. Well, it can be too late, but there's also an opportunity for you to try and stop the transfer. And this is what the Protection from Scams Act actually comes in handy. But having said that, I don't know in this scenario how long it took for David to realize that there was a mistake. I mean, at the end of the day, these transfers do happen. They happen at pace, and there's certain transfers that will take place in certain systems, perhaps faster, or there's less clearance time as well. So a lot of it will depend on how quickly you learn about the issue. So I think what's important to recognize is that if you do find that there is in fact a basis for you to doubt it, and there's often also the desire to verify your doubts. So individuals will say, "Oh, that didn't feel right," and then they might actually treat with the same amount of skepticism they should have used in their first call when they are discovering things that are not right and they're questioning themselves. So they may be able to delay before they said, "Well, I really do think there's a real problem now." And so that's also precious time that's kind of lost as well. But to the extent that you do come to the realization there's an issue, make use of the Protection from Scams Act, report the issue to a police officer, and ensure that you mentioned the fact that there was a transfer, was scheduled for what time, it was paced. So to the extent that they can take action, they can actually give an order as soon as possible.
Totally agree with you, Jeffrey, on that. Especially, I would say that, it would be important to kind of take an action as soon as possible, as soon as you've realized, so that you give an opportunity to the banks and the other institutions as well as the police to actually do something about it. Maybe with that, maybe I think we could move on to the next scenario, which is about a small business, impacted by ransomware. I would see that, this is pretty common these days. There are criminals out there looking to kind of just make a quick buck and install ransomware that would probably give them some benefit on getting to, ask for some money instead. So let's take the example scenario here. TechStart PT Limited, a 25-employee IT consultancy, receives an email that appears to be from a client with an urgent project proposal attachment. More common than we see, actually. The office admin opens the attachment, immediately locking all the company files with ransomware. Now, the attackers demand $50,000 in cryptocurrency within 48 hours, threatening to publish client data on the dark web if payment isn't made. with no recent backups and facing potential PDPA violations. The company feels pressured to pay. They discover that 95% of Singapore organizations in similar situations paid the ransom last year. Maybe I'll probably ask you a couple of questions, Jeffrey, on that. Jeffrey, the company will understandably be under tremendous pressure to pay the ransom. Are there any risks? Are there any legal risks in making such a payment as well?
Absolutely, there is a lot of pressure, and I would say that law firms are not themselves immune. I think, was it last year? One of the more prominent law firms in Singapore was exactly hit by a ransomware, and I think the reports later emerged that they did in fact pay the ransom. And so this, you think about it, this is a law firm. They know the law, they know the legal risks, but when there is a lot of duress on them, they decided that they had no choice but to pay. But the truth of the matter is that if you do pay the ransom, you actually do enter into a number of legal risks as well as real cyber risk as well. The key legal risk is that most of the criminal enterprises that actually engage in ransomware attacks themselves use the funds that they receive often for further criminal enterprise, or they're going to use it to move the money around in systems into money laundering, to clean the funds and give themselves an opportunity to extract wealth. And you should be aware that the payment of any funds to a recipient who could be engaging in criminal activities is itself something that is potentially capable of attracting criminal liability. In other words, you shouldn't be paying criminals, financing their activities, but even with ransom payments, there is a real risk that you might be inadvertently engaging in that activity. And so there is concern about criminal liability in that regard. Do think twice. I do recognize the duress that organizations face, but from the legal perspective, you are also taking on certain risks in relation to making the payment itself. I think the other point to recognize is that there is some study, I believe, that says that organizations who have paid the ransom sometimes open themselves up for repeat attack because they are known to be a target that is willing to pay. So those are further considerations to think about as well. And so these aren't exactly legal risks, but they do sit alongside. They do come from the fact that you appear to be a willing target.
Totally good points actually there, Jeffrey. I think if I may even just add one point to it, I think, when they say that actually the attackers, in case situations like these, they might just even pressure that they have the data that they would release, on the dark web. I think it's also an idea to even just check really if that is a genuine thing, that they have the data in itself, because many of these attacks I've heard even the attackers do not even have actually compromised the data, and they don't even have it. They just try to give it a chance. So I guess that's also one of the things to be thinking about as well. Maybe on that point, Veronica, actually, what do you think the cybersecurity agencies' no ransom initiative, free decryption tools, and how can that help really as well in that case?
So I think firstly, I agree with what Jeff mentioned, that actually it sounds like in such a situation, the organization is being caught between a rock and a hard place. So I think as cybersecurity practitioners, we do recognize that incidents are not a matter of if but when, which is why in the first place, we would say that prevention is always better than cure. And if we can help it, let us not even put ourselves in such a situation. So this is why we advocate putting in place good cyber hygiene practices for protection, and basically the CSA Cyber Essentials is a good starting point. However, given that it's not a matter of if but when, there could be a situation where this is something that you do have to deal with, and this is where you mentioned that the no ransomware project could come in handy. So this is something where, it basically has a collection of decryptors. And while no guarantees that you will necessarily find the decryption key, but potentially there's a collection there that you could be able to use and basically try it out to see if you're able to use it to unlock your data. Having said what I said, I think it's also the case that, number one, ransomware attacks are getting to be now, different facets of it. So the first thing they do is to lock up your data. And this is where having decryption keys would help. but actually in some cases, they have been known to pressurize you by actually putting them up on the dark web, or in some cases, running denial of service attacks on you, really just to make sure that you're being pressured into making payment. So really, I think as a starting point is prevention is better than cure. Let us try to put ourselves in a situation where hopefully we don't have to deal with it.
Totally agree with that. Thanks, Veronica. Appreciate that. Maybe with that, maybe we might want to probably move to the next scenario that will be coming onto your screen in a moment. Sarah works for a healthcare company in a hybrid arrangement, splitting time between home and office, like many of us. Using her personal laptop at a cafe, she receives an urgent email that appears to be from IT support, asking her to click a link to update her security credentials to a system breach. Due to a system breach. The email includes the company logo and references her recent IT ticket. Now, she clicks the link, enters her credentials. Unknown to Sarah, this was a phishing attack that now gives the criminals access to her company's patient database containing 10,000 patient records. This is more common than even we know of, really, as we all seen. The phishing emails is the first way and the easiest way to actually get people to click on something or download something where they can take over the control of the device itself to be able to access some data. Maybe Veronica, I think in these kind of hybrid work environments that we live in these days, how do the environments actually increase these risks? What are the cybersecurity agencies' recommendations for remote work security in that case?
Okay, so perhaps let's contrast the corporate work environment versus a hybrid work environment such as this. So in a typical or traditional corporate environment, the corporate or the organization provides the infrastructure. So this is when you go to work. The network connectivity is provided for by the company. There will be corporate firewalls in place, and basically even your endpoint device, the computer or the laptops that you use, is provided by the company. And because of that, basically end-to-end, the entire environment is quite controlled and basically secured for by the company. But now if you to put yourself in a hybrid work environment, potentially the environment has changed because the employee is no longer using the corporate infrastructure that has been put in place, but the infrastructure of the environment that they happen to be working remotely in. So if we use this example, for example, the person, Sarah, is using the network connectivity that's provided by the cafe. And the natural question is, what is the security of such an infrastructure? There are Wi-Fi networks out there that are known to be evil twins, basically deployed by malicious actors, and they could be basically using the access network to monitor traffic, steal credentials, or even carry out attacks. So in a situation like this, where if you're taking your work device, going to, let's say, a cafe or any other place to do your work, access corporate data, access your corporate work environment, typically we would advise to try not to use the free Wi-Fi hotspots unless you're very sure of security. You could use your mobile connectivity, and also then make use of your corporate VPN to protect that connection to your corporate VPN. The scenario also highlighted the case of the BYOD, bring your own device, where in this case, this was not a corporate device provided by the company, but was actually using the employee's personal laptop to access work-related information. So I think in a BYOD scenario, some corporates disallow that. In others, they would actually have some policies in place, or maybe even measures such as mobile device management to make sure that there's a certain access control over these personal devices. The other approach is maybe to take a risk-based approach. That means to use a BYOD device to access maybe only specific categories of data where the risk is lower and the exposure is also lower. But if we were to put all these into totality, then this would be then a good way to allow for remote work, and it's practical, while creating that safe environment for employees to continue to stay cyber safe.
Some really good points there, Veronica. Actually, I was just thinking about, we all are probably guilty of using airport free Wi-Fi. I'm pretty sure most of us use it. And when we're flying out somewhere, actually, that's the most common one, I suspect. But some really good points there. Jeffrey, on your perspective, what are the PDPA implications in this scenario? And are there any notification requirements to PDPC and the patients in this case? What do we suggest on that?
Yes, so it's true that it's true that for organizations, they permit employees to go into these situations where they can work from different locations, this does increase the potential for risks. And so part of the reason why the PDPA was passed is to ensure that when organizations operate, they raise and lift the standards of their operations and ensure that they institute a culture of data protection. So if the company fails to institute the appropriate reasonable steps to ensure that their work collection, use, and disclosure of personal data is under circumstances which are protected, this would certainly be a situation where the PPA becomes a source of liability for them. Now, in terms of the PDPA, there is a specific obligation for data breach notification. This is an obligation for the organization to report a data breach to two groups of two stakeholders. The first is the PDPC itself, to alert them that there has been a breach. And then the second is to report the breach to affected individuals. Now, the data breach notification obligation only kicks in when certain thresholds are met, and there are two types of thresholds. The first threshold is really about the number of affected individuals. So even if it's trivial data, not important data, but more than 500 individuals are affected, then there is an obligation to report the breach to the PDPC and to the affected individuals. So this could be unimportant information, but because of the number of individuals involved, the obligation applies. The other threshold that can also be triggered is even if it's just one individual which has been impacted, but the type of personal data which has been disclosed is of a sensitive nature. In that situation, there's a risk that an attacker could cause significant harm to the individual. So the significant harm threshold is another trigger for the reporting of the breach to the PDPC and to the individuals. In this scenario, we'll see that it's a healthcare company and that patient database, patient records were compromised. So there is a good potential, there's a good likelihood that the type of information that was compromised could be, in fact, falling within one of the categories of sensitive information, which can include sensitive health information. So certain types of health information, for example, are quite sensitive by their nature. You can think of this as the type of information that could be compromising to patients or could result in real issues for them, whether in society, economically, or in terms of their job prospects or their other relationships. This type of data is sensitive in itself. And so if it is disclosed with perhaps the patient's full personal name, that could result in an automatic requirement for you to actually report to the BPC. Again, even if only one individual is affected. Often when we look at these situations, I always tell the organizations to unpack quickly as soon as possible the information that they get. Often a breach unfolds with information being unpacked gradually or with only additional information coming in from time to time. And despite the fog of war that goes around a particular breach, it's best to try and get as much information and determine whether the breach is reportable. Now, the PDPC does give you 30 days to assess when a breach is reportable, but you're not expected to use the 30 days completely. You're supposed to be acting with full diligence and speed. And essentially, once you determine that the breach is in fact reportable, you then have 3 days to report the breach itself. And the reporting of the breach itself actually requires you to disclose a number of things. It is not just the nature and the data and the number of affected individuals. You also should be disclosing, for example, the chronology of events, which would in fact detail the fact that you were hopefully acting expediently and assessing the breach before determining that it was in fact reportable. You would also be expected to report the breach to individuals, which is to reach out to individuals, in this case, the 10,000 patients involved. And in that scenario, the only situations in which you do not report to the individuals will be quite limited. So, for example, if the data was encrypted, and so there are technological measures in place, then it is possible for the PPC to say that, okay, although the data was exfiltrated or was lost, there are still reasons why The risk of harm is at a level such that the PPC doesn't determine that it's necessary to report to the individuals. It's important for any organization that finds itself in this situation to also be communicative with the PDPC, to start on the assumption that they will be notifying the individuals, but also seek the PDPC's confirmation that there are no objections. Sometimes the PPC can give instructions not to report to the individuals, particularly if there are other investigations going on in parallel and so on. But that would be exceptional. So recognize that if the breach does happen, you actually need to take a lot of steps. And there's a lot of work necessary to get everything in place for the report to be made. And at the same time, there should be evaluation going on to determine what went wrong and to figure out how you can avoid future breaches as well.
Thanks, Jeffrey. I think one of the questions I had, because, and I'm pretty sure that many people actually do get confused about this topic, about the 3-day limit of, the reporting itself. When does that actually start? Your time, time kind of stop, whatever that is, the time start. When is that 3 days? When do we take a decision of that has to be done within from, starting at this point because, they've identified something?
Right. So that actually begins from the moment that the clock starts ticking, from the moment you determine and you make an assessment that the breach is reportable. Now, it's a bit different from how I see that worded in other jurisdictions. Sometimes in other jurisdictions, it's just worded simply as the moment a breach is discovered, right? Whereas there is a question of assessment that is explicitly contemplated for by the PDPC in its guidelines. So it's worth noting that the PDPC does understand that there is a need to assess the severity of every breach or the nature of the breach. It does give you time to do that, but please do not take that as an excuse to drag out the reporting and assessment process. You are expected to act expediently and not to waste any time in determining whether it is reportable or not.
Good point there, actually. Thanks for that, Jeffrey. Maybe we might want to probably move to the next scenario, actually. This is the last scenario for us before we get to the questions. I've seen that there are a lot of questions coming in as well. So I would like to kind of dedicate some time to the questions after this scenario. So hopefully in the next 10 minutes or 5 minutes, we will get started with the questions as well. So the next scenario is pretty much on the QR code malware attack. We all know we use QR code on a day-to-day basis everywhere, literally in Singapore, in terms of payments, in terms of, going and scanning, sitting in a restaurant, scanning for a, menu itself. There's a lot of places we use QR code, and it's pretty common. So the scenario is pretty much dedicated on that. Jennifer visits a popular bubble tea shop in Orchard Road and notices a QR code on the table advertising a survey for a free drink. She scans the code with her smartphone, but instead of a survey, her phone actually downloads a malware, a keylogger app that requests permission to read SMS messages. Thinking it's part of the survey process, she grants permission. That night, while she sleeps, cybercriminals use the keylogger to capture her banking OTPs and drain $15,000 from her savings account. Maybe, Veronica, I think I might probably pick your brains on this one, but mobile device security. Why do people neglect actually this kind of a smartphone protection, do you think? And are there any guidelines that Cybersecurity Agency does provide for that mobile security as well?
So I think firstly, there is a very natural tension between security and convenience. So when we use mobile phones extensively, it's actually really because it's convenient. And the moment we introduce security measures, it introduces friction into the process, and that really gets into the way of the convenience, which is why between these two, there's this very natural tension. The additional factor is that when we use mobile phones, it's very much typically when we are on the go. We are busy, we are easily distracted, and this actually also renders us vulnerable to some of these attacks, especially in a scenario of social engineering. The other point to consider is that your mobile phone screen is really small compared to your laptop, to your tablets. And when we need to verify links, for example, it's actually much harder to do this on a smaller screen compared to a larger screen. Mobile phones are actually getting increasingly powerful, and powerful from the perspective of compute, but also powerful from the perspective of the number of things and the transactions we can run on the mobile phone. So if you were to take the typical cybersecurity measures or the cyber hygiene measures that we want to put on a laptop onto a mobile phone, I think it's increasingly defensible that we think about it this way. So some of the measures that we would think about would be, number one, update software frequently. I talked about this previously in my sharing, and actually we've also seen some cases where there are major vulnerabilities in, let's say, the operating system, and that's where there will be advisories going out to update the software or the operating system as soon as possible so that it's not vulnerable. The other one that's quite interesting is basically advice or guidance from the National Security Agency and the Australian Prime Minister. So what they said is reboot your smartphones once a week in the context of the NSA or every night in the context of the Australian Prime Minister. But essentially it's the same thing, is to reboot it to mitigate hacking. So basically the thinking behind that piece of advice is that when you reboot the phone, it forcibly closes the applications or the processes that could be running in the background, and this could actually stop the malicious actors from monitoring you or to collect your data. Other measures would be things like downloading your apps from trusted sources, such as the official app stores. So try not to get into site-loaded applications. And also look at installing security apps on your mobile phone. So CSA, the Cybersecurity Agency of Singapore, does have a list of recommended security apps for the mobile phone that you may want to think about and to check out on our website.
Thanks so much, Veronica. I think that really was interesting, actually, about specifically the reboot and the restart of the phone. I think that was interesting advice there. I think one advice, if I would probably to give to a general audience, would be is to, before clicking on a link or anything like that or downloading any attachments, the best thing is always just copy the link without actually clicking on it, and maybe just copy into a separate browser and open a website called virustotal.com. That is basically a checking website to make sure that it's not a phishing page. It's not a malicious page. It's a free tool basically provided by Google. And you basically paste your link or your document, upload your document if you can. It basically checks the link itself for you and gives you an indication of whether this link is a malicious link or not. On that point, actually, Jeffrey, I think I probably would want to probably understand who is liable for the loss that Jennifer suffers in this scenario. Actually, the merchant? Is it the bank? Is it the customer's responsibility?
Well, that's an interesting question. And I remember looking at this scenario and wondering to myself, what's the distinction between the fact that the QR code was visible at the bubble tea shop's premises versus, say, a random message sent by someone forwarding, a link that was essentially used for launching the keylogger, but pretending to be labeled as coming from the bubble tea shop, right? So the difference just appears to be the way in which the QR code or the malicious link was delivered. And in this situation, I guess you could make an argument that, well, the bubble tea shop is within, well, the assumption is the table is within the bubble tea shop, right? So these are premises which the bubble tea shop has some control over. And I suppose to that extent, there would be questions that could be asked about whether the bubble tea shop should have taken some amount of care to ensure that such malicious messages or stickers are not appearing on their own premises. They do have some control over it, but at the same time, we do have to recognize that, well, the individual him herself or herself in this case actually does need to also exercise their own share of responsibility for ensuring that they are careful with the data and their engagements with the devices. So it's not a real easy answer in this regard, but depending on whether you're thinking, okay, look, I'm looking for redress. Well, one question really is, have the parties involved in every situation taken the appropriate steps to prevent the losses or risks that could happen? Could they have taken reasonable steps? I think at the one level, you could sort of make the case that, yeah, the bubble tea shop could have taken reasonable steps to have control, exercise the control that they have over their premises to avoid malicious, hazardous things sitting within their organization, their premises that could have led to this. But at the same time, the other situation to think about is whether there were appropriate steps taken by the individual here to prevent or to cause, to take the necessary precautions or have malware, antivirus detection put in as well. So on the whole, I would say that between the individual and the organization, in this situation, the organization does carry a little bit more responsibility because they have control over the venue in which the QR code was in fact visible. And that's a little bit different from where a random message was sent by an unknown source purporting to be that organization, right? In that situation, I think all of us do recognize that there was nothing the company then in that situation could have done. Now, at the same time, I think you could also make a case about the banking organization itself. We can see the banks essentially are also adding more and more security around transactions. And so we're seeing additional steps being taken in this regard. So to the extent that you can avail yourself of these particular security measures, that would be, again, something that the user, the individual himself, should be bearing in mind when taking these free offers or acting on these activities. It's important to essentially exercise a certain degree of personal responsibility.
Thank you, Jeffrey. Really appreciate that. Now, I guess we're pretty close to the closure of that scenarios. So thank you, Jeffrey and Veronica. Maybe we should probably pick up some questions from submitted by the audience, and there's a long list as I mentioned before. As a reminder to our audience, you can still submit some questions if you like, but I'll be very cautious in picking questions right now. We got about 20 questions nearly sitting here. So maybe if I may get started with the first question, it would be, I'll pick up random ones here because I have a long list to go through, and we may not have enough time to go through actually all of them. So maybe I'll probably start with the easiest one here. I'll keep it open to both of you, and I think if you can decide which one would be best for you to pick up. Company A actually emailed a document with clients' personal data and sensitive information to Company B without password protection. Does this actually put the client at risk of data breach, and what can they do about it? Jeffrey, do you want to probably?
Okay, I'm assuming that the transfer is authorized. In other words, company A and B are supposed to be exchanging information. But absolutely, there is a real risk here in terms of if the communication was intercepted or the file was somehow accessed without authorization. The fact that the company didn't take steps to protect the information such that perhaps encrypting it or adding a password protection, these are reasonable steps that in today's world we would not, as a matter of commercial responsibility in communications, avoid. We would, as a matter of standard operational protocol, consider that to be something that would be a default that we should be using. So I think there is a real issue here in terms of exposing yourself to potential risks.
Totally agree with that. Yeah. And maybe Veronica might pick up one because you mentioned about the Scam Shield app from the government. Actually, you mentioned there. Does the government's Scam Shield app help actually block any scam or spam calls and messages, really?
Yeah, I think it is intended to do that. So this is actually a scam prevention tool. So apart from checking for scams, it also helps in blocking and filtering scams. And on top of that, also has an interface for you to help to report potential scams. So in a way, it is more than just a blocking, but it's also then basically reporting mechanism as well.
Thanks so much, Veronica. I think maybe the next question is more towards a privacy question here. So someone has mentioned that I am a DPO. Is DPO considered an employee for the purpose of the PDPA so that the DPO can claim S4 defense against a civil claim under the PDPA? Well, I think I'll probably leave Jeffrey to answer, but I think I've been in DPO roles for about 10 years now, actually, in across the globe as such. It certainly can be an employee, potentially, or it can be an external, a third-party person acting as a DPO on behalf of the organization as well. But I'll let Jeffrey answer a bit more details around the PDPA side of things.
Right. So the question was whether the DPO is an employee.
Yeah.
Conceptually, there's no need for an employee, for a DPO to be an employee, so they're not identical. And the DPO really is exercising an office that is required of an organization to comply with the accountability organization in obligation and other obligations in implementing practices for the organization that comply with the PDPA. So the DPO's role isn't framed as primarily one that's done by an employee. It's simply something that's imposed upon an organization to ensure that it implements and it uses the DPO for that purpose. The individual is usually an employee, but not all necessarily so. I think it's important to recognize that the DPO can take. There is personal liability prescribed to certain individuals if there are breaches of the act for which there are criminal sanctions imposed. Not all breaches of the act lead to criminal sanctions which expose individuals to direct criminal liability. There's a number of them. For example, the fact that you might mislead an investigating officer, there's a very specific criminal sanction linked to that. So if you consent to connive or you in some way perpetrate that type of misleading, that creates a personal liability on the officer itself. But generally speaking, organizations, people playing the role of the DPO should recognize that, yes, they do have responsibilities to do their part, but the actual availability of criminal sanctions against them directly, there's not a ton of them, right? It is very limited in terms of scope. So I wouldn't be so concerned about personal liability in that regard. I would see it as more of ensuring that there is an obligation on the organization as a whole to execute it, and you as the DPO are a key linchpin of that. I did used to joke to people who I used to train on PPA. I said the DPO is not a person who goes to jail on your behalf, right? He's not a person that's your fall guy. Actually, he plays a very important role, and in that sense, you do rest assured that as long as you do a reasonable job of attending to your duties, you have really nothing to fear in terms of your personal liability under the PDPA.
Thanks, Jeffrey. Appreciate that. I think it's very good. Maybe I think the next question, Veronica, I might probably focus on you for that one. Really, there is so someone has mentioned that I am a small startup. We received an email from an ethical hacker saying vulnerabilities were detected. On the website. I'm assuming that they have a website and there is some vulnerabilities being identified, and they basically they're basically asking whether if they do ask for any compensation, is that something that they are bound to receive, and what should kind of companies like startups like these should do in that respect? I mean, my personal view, being professional in cybersecurity actually for such a long time, over 2 decades. Personally, the way I see it is you're not liable to pay anything if you don't want to. It's up to you, of course. It's always a kind of a token of appreciation, the way I see it. Veronica, I might want to take your get your take on that one as well.
I suppose when you say you receive an email from an ethical hacker, and whether this ethical hacker seems to be asking for compensation for spotting such vulnerabilities, you can probably take it from a different perspectives. I think one is from the positive perspective that there is somebody out there that's letting you know that you're vulnerable. And I think regardless of whether you continue to engage this ethical hacker or basically some other ways, is actually to try to spot these vulnerabilities, whether it's in the form of engaging licensed cybersecurity pen testers for you to be able to spot your vulnerabilities, or in some cases it's actually to get hold of some of these tools that will help you to do scanning from the outside to figure out what are the areas of vulnerabilities. The other perspective is also come from the perspective of something like a bug bounty, where you could put yourself out there to say that actually I'm putting this out for a bug bounty, and if people are able to identify certain issues, then there will be a payment for it. So I think these are some possible ways for the small organizations to be able to move forward, try to uncover or discover what the vulnerability is, and basically, most importantly, to close it. And this would be, I think, being proactive about it.
Really well said, actually, Veronica, on the bug bounty part. Especially, I've seen many organizations, bug bounty organizations, which actually allow, ethical hackers to be part of an organization where they can actually consider, doing all of these things anyways, ethically as such in that case. So maybe next question, I think maybe Jeffrey, I might take your take on this one. It seems like, example, if an organization, an organization was impacted because somebody as an employee did download some malicious attachment without realizing, or clicked some malicious link and did, impact the business by downloading some malware that either took them like a ransomware or things of that, and it caused basically some damages to them. In such a situation, can the organization actually sue the employee for downloading any such thing and then having that impact on the business itself?
Well, that's a fairly grim question to ask. I mean, I think employees all owe duties of certain duties to their employers. It's true, right? You would have duties of diligence. For example, you must execute your functions with care and so on. And so I guess in that area of law, there is an element under which an employee could be theoretically liable to an organization. But I must say that if an employer takes legal action against his employee for what is essentially, well, I suppose, a lapse of judgment or something, but nothing malicious, nothing like fraud, it sends a very difficult signal to the rest of your employees, and so yes, in theory there is some element of duty owed by the employee to the employer to discharge their responsibilities with due care, and so if there is a breach of that duty, then there's theoretically liability. But I think if you were the employer, you do need to think twice. I mean, all individuals, we're all human, we all do make mistakes. And you have to be wary also of the fact that to some extent, as an employer, you owe obligations to ensure that your employees are properly trained or properly equipped and that they have the tools to execute their duties. So, if it came down to a dispute between who was responsible, you could say that it's difficult to just throw all the blame on an employee, right? So if they weren't given training, if they weren't given the means to be able to take appropriate steps, they weren't given an SOP, for example, to follow when ensuring that they're handling personal data, then at the same time, I think the employer would have to sort of understand that perhaps they have fallen short as well. So it's important to see the picture in the larger context.
Thanks, Jeffrey. I think I have a similar sort of side of question around there, actually, not exactly the same, but more on the impersonation as well. So if someone as a scammer actually has impersonated you through photographs and other means to solicit some funds from someone of really as such, what recourse actually there is for the victim being impersonated in this case?
Well, I guess the first question really is, what is the remedy that the individual would like, right? So, you see, the laws which are evolving around the space concerning the use of deepfakes and takedowns, that is available to you, perhaps, in the case of online harms. That legislation does give you the opportunity to take certain redress. But in the situation where your identity was taken and used to perpetrate a crime, the idea that you might want to pursue the organization or the entities or the criminals who effectively made use of your personal data or your likeness to perpetuate the harm is something that I suppose could be theoretically framed as a matter of criminal complaint that you could make to initiate the fact that someone has actually executed a crime using your persona, your identity, and that it's also available even in the offline world, right? So it was never exclusively a matter of online concerns, but usually these complaints would come from the victims of the harm. So yeah, it's possible for you, I think, to make an appropriate application or a complaint filed with the relevant authorities. We just need to make sure that we're separating this from the more emergent area of law that we see, where governments are essentially trying to empower individuals to take back control of their likenesses. I mean, in other countries, for example, there's a Scandinavian country that has actually passed, for example, a law to extend copyright control over to a person's likeness. And that's an interesting development there. But you can see that governments all over the world are trying to extend the rights of autonomy over your image and your likeness in different ways. And that part of the law is always evolving. It's not necessarily linked to just scams, but recognize that, yes, if you felt that there was a crime though that took place, and then your persona was used, you would make the appropriate report to the police to engage the relevant authorities and call upon the appropriate enforcements. But it is not, it's different. It's a different interest from merely just stopping your use of your likeness. It is to stop a crime or to report a crime where there was a victim of that scam or fraud.
Some great advice, Jeffrey, there. I actually appreciate that. I think, Veronica, I have got a couple of questions which are quite similar. So I'm going to take, given that we need conscious of time, we've only got a few more minutes left. I'm going to combine a couple of questions here for you. Maybe the first question is, it's, many of us, probably most of us, use online wallets, Google Pay, GrabPay, and all the others. Really, are they really safe to use? That's the question one. I guess I'm going to combine a second question to it is, how risky it is actually to use Pay Now for payment of merchandise. Related questions, I thought.
Okay, so I think firstly, when we look at the wallet itself, I think the first thing is to really look at the track record of the wallet provider, and basically whether the provider has been having a good cybersecurity posture, responsible attitude towards upgrading it as and when the vulnerabilities identified and so on. So that would be the first thing that we'll think about. And if these are reputable providers that have been out there and well scrutinized and so on, chances are from a technological perspective, from a protocol perspective, they could be safe. However, there will always be dangers. For example, earlier on, we talked about how there could be, for example, social engineering, where while the wallet itself is safe, but the person has been scammed or tricked into basically revealing some information. And therefore, once the credentials are released, for example, then this is where the dangers would happen. In other cases might then be not so much the wallet itself is not safe, but the device itself has been compromised. So I think when you think about it, it is not really just the wallet itself, it's also the user, the device, and the entire environment. And basically to make sure that end-to-end, all these packaged together, we have the right measures to make sure that we are protected. So it's not really just about the wallet or the application.
Thanks so much, Veronica. I think with that, I think I might probably take one more question there. We got a few more minutes that potentially would be useful for taking one more there. Veronica, you did also actually talk about anyways on, the mobile safety and security. I think there's a question which is related to that. Maybe you can just probably, either give some more points if you have things like that. How to prevent to keeping your handphone safe from being controlled and not being hacked by another person.
I guess some of the points we covered earlier about software updates, about things like making sure that we are responsible in what we download, the applications from trusted sources. This would be, I think, good measures that we want to implement. Also then what the Australian Prime Minister said, which is actually to then reboot your phone frequently so that when you have background processes, it basically kills off these background processes.
Thanks so much, Veronica. Maybe Jeffrey, I think just one last question. I'm being tempted to take one more really because we've got a couple of more minutes. So if I have an online website on social media and it got hacked by, hackers or attackers, cyber criminals, how to seek actually legal redress, and is it even possible to do so? What if they also demand a ransom to it?
That assumes you know who has hacked your site, right? And so where to direct your legal action to. Most of the time when it comes to these activities, it's actually hard to find the identity of the party who's perpetrating the attack. But to the extent that you can find a target and you were able to prove that was the source of the attack, yes, there are legal remedies that can be pursued. And it's a mixture as well of civil and criminal liabilities. I think the easiest one is to start with a criminal report, right? So to the extent that you can file a report with the police, they would be able to start investigating a breach of the Computer Misuse Act, and that would initiate its own life of its own with the prosecutor taking action against them. And then there is the potential for you to take the civil litigation. The exact cause of action or the basis on which you actually bring a legal action will vary according to what was actually undertaken, what happened. In the case of, say, if you were talking about legislation such as the PDPA, the right of private action actually is in respect of the data subjects, the individuals who are affected. So it's not necessarily that you would find a legal action under the PDPA to go after the organization if you were not the affected individual in question. But there are other types of civil litigation actions that could be undertaken. It will depend on the facts in question. But I would say that really, as a starting point, go with the criminal report first and initiate an action that way, because effectively, if you get a good outcome that way, it also makes it easier for you to bring a civil litigation to follow.
Extremely valuable advice, Jeffrey. Thanks for that. Now, we're sadly out of time. I would like to invite kind of each of you just to kind of give us a 30 seconds takeaway message for the audience, really, if you like. Jeffrey, I might probably start with you.
I guess the one that we gave earlier, that you do need to do your part, is the key one. At the end of the day, the law is evolving as quickly as it can to provide redress and rights to you. But all these would not be as important as you individually stepping up and taking responsibility for your own cyber safety.
Thank you so much, Jeffrey. Appreciate that. Veronica, from you.
I'd like to mention a quote by Bruce Schneier, a famous cryptographer, and he said this: "Amateurs hack systems, professionals, they hack people." So I think very often when we look at the people, process, and the technology of cybersecurity, we always think about the technologies that we implement, and we also then implement processes, but we often forget that actually people are the most important part of the entire equation, and people are much easier to hack compared to the nearest technology. So I think all of us, as humans, let us take our roles seriously to be able to make sure that we're as unhackable as possible.
That's a great message. Thank you so much, Veronica, and thank you, Jeffrey, again, really. Now, we have to unfortunately bring our session to a close. We only got a couple of minutes here. So our next webinar will be Youth Offenses and Bullying, legal guidance for parents and educators, happening on the 22nd of October at 7:30 p.m. The session will explore what happens when a young person breaks a law, how bullying and harassment are treated under the law, and the role of schools, parents, and the justice system. You will also hear about the early intervention strategies and the support options available to guide youth back on the track. This session offers practical legal insights and tools to help you support young people with clarity, care, and accountability. Now, this and many other more webinars are part of the Law Awareness Weeks at CDC 2025. You can click on the link shared in the chat function to visit the website to register for the next webinar or the many more webinars available. If you missed any of the webinars and wish to catch on once you missed, the recordings of all Law at CDC webinars will be made available on the Pro Bono SG's YouTube channel 2 weeks after the end of the live webinar. You can check out the link shared in the chat function. If you missed clicking on any of the links shared during today's webinar, do not worry. All links will be shared all links shared in today's webinar will also be provided in the follow-up email that will be sent to you tomorrow. Do watch out for it. At the end of the webinar, a survey form will pop up on your screen for completion. We appreciate your comments, and as it would be useful for us to improve our future webinars. After today's fantastic sharing from our panelists, if you find that you require legal guidance on your legal issue, do write to us on help@probono.sg. And lastly, we would like to express our gratitude to Jeffrey and Veronica for sharing their knowledge and experience with us. With that, on behalf of Pro Bono SG, we would like to thank all of you for joining us today and have a lovely week ahead. Thank you.